2026, Assumpta language.
Now we are ready to proceed.
Yes.
Then I'm going to have this matter withdrawn under Section 87, the Criminal Procedure Code. The witnesses with respect to this matter were not in court today in view of the confusion in the court lists.
Yeah. Whereas we appreciate the gesture by my learned sister, I'll be opposed to the withdrawal of the charges under Section 87 for obvious reasons. But even with a withdrawal under Section 87, they can rearrest my client just outside here and they charge her afresh. It does not insulate her from subsequent rearrest and charge. Now, in view of your earlier ruling, a ruling that was clear, a ruling that was considered, I'll be making an application under Section 202 of the CPC, which if you allow me, Your Honor, I can read verbatim.
Yes.
The provision provides that in a case which a subordinate, in fact, let me start, it falls under Part 4 of the CPC, and it defines procedure, criminal proceedings in subordinate courts. The provision provides in a case which a subordinate court has jurisdiction to hear and determine, the accused person appears in obedience to the summons served upon him at the time and place appointed in the summons for the hearing of the case, or is brought before the court under the arrest. Then, if the complainant, having the notice of the time and place appointed for the hearing of the charge, does not appear, the court shall thereupon acquit the accused. And I want to emphasize the word shall. It is couched in mandatory terms. It is not discretionary. Upon the court rejecting the adjournment, if the complainant, the witnesses are not in court, the court has no other option other than to acquit the accused person. Your Honor, the prosecution, the witnesses, the prosecution witnesses knew of the date, they knew of the place, they knew of the time for this hearing. So the case clearly falls squarely under the provisions of Section 202 of the CPC. So with a lot of humility, Your Honor, with a lot of respect for the prosecution, she has done her best, but this is a dead horse which she can't flog anymore. I urge the court to acquit the client, let her be free, and let this be a lesson to the prosecution. Send a message. Indeed, it is the duty of this court under the new constitutional order to strike a rule, to strike a blow for the rule of law. Send a message. Criminal justice system should never be abused for ulterior agenda, which clearly has been the case in this case. I urge the court to strike a blow, a hard blow for the rule of law. That is all.
Your neighbor may respond.
Yes.
Section 202 envisages a situation where the complainants and the witnesses were notified and they are not in court. In this instance, as I indicated earlier, we thought the matter is coming up for tomorrow. The complainants and witnesses.
You had ruled on that aspect of knowledge of the date. You had ruled that's a matter of court record, not a diary, on our own perceptions of mistake. So she's inviting you to rule again on the same issue. I think that issue is now behind us. If I already made a ruling on that, I'll object to that line of submission.
Yes, prosecutor.
Your Honor had indicated in my request for an adjournment, which was declined, that we thought the matter is coming up tomorrow. And the other reason was that the file was with the DPP. The complainants and witnesses in this case, therefore, had no notice of today's date. In fact, I was equally surprised to meet my seniors here. I'm therefore praying that the matter be withdrawn under section 87A, which will be the appropriate section in the circumstances.
I've had the application by the prosecution seeking to have the matter withdrawn under section 87A of the CPC, which again is opposed by the learned counsel for the accused person. Have been extensively referred to section 202 of the CPC. For clarity, section 202 refers to where the refers to where there is non-attendance of the complainant, the place and time appointed for trial. It too envisages a situation where the accused is present at the appointed place of trial in obedience with summons. In this case, the accused person is present in court, the place appointed for trial. The complainant is absent. The prosecution cited no knowledge of the complainant on the place and date appointed for trial. Notably, and as earlier submitted, the witnesses were not bonded, hence the knowledge on the place and time of trial is in doubt. In the premise, I find for the prosecution and I hereby allow the withdrawal of the matter under Section 87 of the CPC. The accused person is accordingly discharged under the section, cash bail deposited in court to be refunded to the depositor.
Much obliged. We are grateful for the time.
Thank you.